allowing you to?
Sweet.
Okay, cool. Okay, so let's just go back to that one. Okay, so what I've done is just drawn up a sample for this. And the important thing is we're trying to remember, we're trying to create the record which will allow us to move this into courts. We're not here to just sit and do a little bit and a half-hearted job. The intent is to move it into courts. So to do that, we must create a proper record. So this is a format for the record that you'll keep to see what's the progress of each notice that you've served. So basically, put your name, name your register, your notice register. So I've just basically put notice register of, and if it was mine, I would say Mark Horn. Then we've got the details of the first notice, of the second notice, of the third notice. So down here, we've got the notice number, then the person who's serving the notice and upon whom it was served. Then the date it was served, when a response is due, and have they complied. If they've not complied with your requested remedy, you send notice 2. Date served, response due, have they complied. If they don't respond, you send notice 3, date served, response due, have they complied. So this way, for one notice, we can use one line for the whole process. So let me just go back then to the other one that we had. Oh, come on. I do have to stop sharing screens again. Hang on. Let me just go back and swap back.
And Mark, in your opinion, what's a reasonable time frame for a notice?
Okay, we'll be going through it now, and we'll be answering that question. You'll see why and how you determine that.
Oh, thank you.
Okay. So basically, back then to the notice itself. So this is why we need a unique number for each notice so we can keep track of it for our record. The next line is, it's a notice to principal is notice to agent. Notice to agent is notice to principal. And we'll talk about that when we get there just now. The third thing is, it's asking them to cease their claimed enforcement rights and desist until this dispute is settled, because that's really how simple our interactions should be between people. It should never, there's no need for it to be more complicated than this. So it starts off when. So the first point is when, second point is where. Now, this is where the incident occurred. So for instance, if—
You're sharing the screen at the moment, or not?
Oh, shit. Oops, sorry, excuse my French. It's being recorded, I've got to watch what I say.
Don't worry about it.
Oh, damn. Share screen, boom. Share, there we go. Cool, sorry about that, thanks, Dwayne. Okay, so the caution is what the notice is titled, our reference of the notice. Notice to principal is notice to agent is notice to principal, and it's a cease and desist notice. So we start off when, so this day of the year, blah, blah, blah. Where was the incident? Now, where was the incident would be, for instance, if you're at a supermarket and somebody asks you to wear a mask. If you want to just serve proactively, and if you see some signs up or somebody doing something, like, for instance, we've asked supermarkets to remove all their propaganda. in regards to COVID-19, we would just say where we saw it. Next is in my own right. Now, this is what everything hinges upon. We are standing in our own right as equal creators of the law, as all are equal under the law and nobody's above the law. We're not subservient. We are all equal under the law. So in my own right, each of us is in their own right. And that's the state of mind that we're moving towards. I, and then put your name. So plonk your name in there. Of, plonk your address there. Again, we're standing as sovereigns, as equals, without fear. So we shouldn't be scared of, oh, lovely, thank you. We shouldn't be scared of letting people know who we are and where we're from, because we're proud of who we are and what we're doing. Next thing then is the statement that I'm granted, Carrie, stop it. I'm granted my mind by the Creator, who or whatever you may believe that to be, and I'm the sole beneficiary of my body. And basically that there is referenced then down at the bottom, and this is the case law that it relies upon. So that's statement here is supported in law by this, and that is what's called standing, i.e. I stand upon what I say, and here's my proof and evidence. So in my own right, with my own mind and beneficiary of my body, I can explore this reality dictated by my conscience, provided I knowingly do no other harm. And legal until 18, and lawful whilst dependent, guardian of my children. So you put in your children's names here, and you guys are talking about serving schools. So you would put in the children's names there. Next, you are telling them how you want them to respond to you. You're a king, and this is how you want them to respond. So you can either have them send snail mail to your address or email. I suggest we do it by email, that the communications gets done by email, because that way we can use witnesses. Now I've got here 2 witness email addresses, which are basically addresses that, hang on. Okay, these are witness email addresses. Now we need to put in here a reference that's missing. Insert footnotes. Let me just find the reference and copy and paste that in. Where is it? It's in here. Where's the reference here? Okay, this here is the legal reference to support that we can do email service. Okay, this was a precedent set in this case by a company that was trying to screw the little people over, and now's the time for it to backfire on these people. So what happens with this is when you send the notices, if you do it by email, include these 2 addresses as witness email addresses. It's a account that I've got access to, and when they respond, they should respond also to your 2 witnesses. If ever we need it, we can use this as proof of service. So that's your details then. then you move on to, I do herewith serve you. Okay, now I've put the person, the title of their office, and the organization. So put in here the details, put in the person's name, their title of their office, and the organization. This will become clear to you just now when we talk about notice to agent, notice to principal, so that you can understand why we're doing all three. And then their address, and if they accept email service, put in their email service address. I've left space here for 3 individual people that you can serve in one notice. So it's designed at the moment for a maximum of 3 people. But I need to just reformat that. Hang on, just make a bit of space. That'll have to be single. Okay. Then, so that there basically is when, where, who. Okay, now we start to move on to the whys. So what I'm trying to do is this, the idea of this is that it's educative to both the person serving the notice as well as the person receiving the notice. So my notices tend to be longer than necessary.
So if you've got a governing body, sorry to butt in. If you've got a governing body and you know there's one lady, for instance, who administers and looks after the governing body, and you don't necessarily have her address, would it be best to use the school address and just because ultimately she's a representative of the school on behalf of the governing body, and then you
let's just quickly talk about this here. Notice to principal, notice to agent, because that may well answer the question you're asking. So basically, a governing body is a fiction of law or a straw man, and that person that you've described, Dwayne, is a agent of that principal. So by serving them, they must notify their principals. So it doesn't matter if we do the toilet cleaner, okay? If you, whoever you serve, it doesn't matter, because they must tell all of their principals and they must tell all of their agents. And every principal then must also immediately notify their principals and their agents. Okay, and what we're notifying them of is that the lawfulness of the claim is their claim. Whoever we've served here, whatever they've done, is unlawful, and we're disputing that. Does that answer your question, Dwayne?
Yes.
Okay, great. Okay. So next, now what I'm using is here in purple, I've got all of the fundamental principles of the law. So what we're saying is we're starting ignorance of the law is no excuse, i.e. I'm going to tell you what the rules of the game are. This is the law. Now we're going to look specifically, all are equal under the law, nobody is above the law, and the concept of innocent until proven guilty. Now you'll see that I've put in brackets here sort of what we can understand by this. So ignorance of the law means natural law will always prevail, truth is sovereign. All are equal under the law means no privileges, what you can do, I can do. No one is above the law means no immunity. We are all accountable in person for harm we cause. And innocent until proven guilty is the claimant must prove their case. So based upon these 4 fundamental precepts of law, what we're saying is you must cease and desist. You must prove your assumptions, and presumptions are lawful. So this notice lawfully is with their knowledge, and it's about disputing the lawfulness of their claim. and their claim is any right of enforcement. So we're telling them you must immediately cease further enforcement as the claimant must prove their case, and your belief that another, i.e. I or anybody else, is under an obligation to perform your commands, who are innocent until proven guilty. So I'm trying to reinforce the use of the words so that people understand this. B, your claimed rights, and then in brackets, presumptions and assumptions. Okay, we want to remove all presumptions and assumptions. That's what this is all about. Stop these presumptions and assumptions. And we're saying they're causing a breach of the people's peace, specifically causing fear, alarm, and distress by your discrimination and harassment, by misrepresentation of humanity's best available knowledge in respect of. Okay, so then this section here, once you got the notice template, you can just fill in whatever you like and modify it however you want. So what I'm saying in this one, because this is CB related, unsupported suggestions and action regarding COVID-19, and in particular about social distancing, about face coverings, about testing, about isolation, lockdowns, vaccinations, vaccine passports, discrimination based upon tests or vaccination status. So, like I say, these actions by somebody else are causing fear, alarm, and distress. Now, when asked, you have failed to provide evidence on the balance of probabilities, which is the civil test, let alone beyond any reasonable doubt, which is the criminal test, showing the claimed virus exists and the claimed virus causes unique harm, and that the claimed virus is transmissible human to human. So this is what we're disputing. We're saying this first portion is creating alarm and distress and breaching our peace. And the reason is because you've failed. It's breaching our peace because you've failed to provide evidence to show that your claim is legitimate. You've got a legitimate cause of action. Everybody okay with that so far?
Yeah, so I mean, obviously, I'm sure you're going to mention it, but it's just in regards to they always default to we're following government guidelines. So
correct. Yeah. Okay. So basically, what we're saying here now is exactly what Dwayne was saying, thereby making your, i.e. the person that's asking me to do this, actions irrational and hence unlawful as further detailed below, or as detailed below. So basically, now we go on to failure to provide the above evidence further affirms the Coronavirus Act 2020, secondary legislation dealing with coronavirus, health and safety policies, and risk assessments prescribing any preventative measure against coronavirus are illegal, as well as being unlawful. And then we're asking them to keep the people's peace. You must desist your believed right until this dispute is settled by proving your actions are lawful, as I'm innocent until proven guilty. Further, now that you're with this knowledge, failure to settle your claim is a breach of my peace. So what we're saying is this person here who's made the claim, okay, it doesn't matter if you're using Coronavirus Act 2020 or secondary legislation or health and safety policy or your risk assessment, okay, they all are illegal and unlawful. Does that clarify that, Dwayne? Yeah, cool. Okay. The next thing then.
Mark, excuse me. There is a word you use, legal and lawful.
Yeah.
Could you explain to me, what is the difference?
Okay. Let me just finish this mouthful. Okay. Legal sorry, start with lawful. My word is my bond, and through my word, I create or agree to obligations and rights. So if I said to you, how's about we make an agreement? If I email you this document, you will send me £1. If you accept that offer, then my word, and we do this verbally, that is the law. So we create the law through our verbal expressions. If we then confirm that in writing, that is merely a written form of the law, and that's what legal means. Is that clear enough, Emeka?
Yes, thank you, Mark. Yeah, thank you. Yeah.
Okay.
So legal is much more stronger, and yeah. Thank you.
Is it much stronger?
Yeah.
It depends. Basically, legal is the written expression of the intent of what was spoken.
Right.
And we don't always express ourselves accurately, and therefore it still may be subject to dispute.
Sorry, just a moment.
Yeah.
Sorry. Sorry, Leo had the problem with microphone or something. I'm sorry. Yes, but the anything like the verbally agreed, that is already law, isn't it?
That's the law, yes.
Yes. Okay. Yeah.
Now the thing is, often we may forget what we said, and therefore it's always better to write it down.
Yeah.
And we need the freedom of speech to be able to express ourselves. And once we can express ourselves accurately, then it reduces the chances of one person saying, oh, but you said this and you've written that. So the final written version is the one which tends to prevail.
Oh, yes, of course. Yeah.
So because that there is looked at as the written expression of the final intent of the words.
Yes.
Okay.
Yes. Okay. Thank you. That's clear now.
Okay. Only following a meeting of the minds. Again, that's called full disclosure. By humans consenting by their free will, can rights and obligations be created, enforceable by the community against one another. So like we just had there in that quick discussion, this is how we create it. We speak it, we negotiate, we have a meeting of the minds, and then we express it. And that is what creates rights and obligations. Okay. Nobody can enforce any right or obligation upon you unless there's consent. Okay. And consent means free will. Free will means no coercion, no playing with words, no fancy tricks, no anything. Because if ever there's fancy tricks or anything, or dual meanings of words or manipulation or assumptions and presumptions, there cannot have been a meeting of the minds. And therefore, you cannot be under a right or an obligation. And this is basic contract law. If there's not a meeting of the minds, then there can be no rights and no obligations. Okay. The next point is that equity prevails, granting lawful excuse in the event of a conflict between the rules of equity and common law. And then in brackets, just to make clear, these are common law judgments that we're talking about. So what this is affirming is that equity acts in person, i.e. the highest rule, equity prevails. It stands above the common law. Okay. And the common law is reached by dispute settlement in court judgments. So equity, which is about following my conscience, it acts in person, not on legal fictions, and it will not suffer wrong without a remedy. Okay. this is why, going back earlier when I was saying, well, no one's above the law, there is no such thing as lawful immunity. There's only such thing as legal immunity. Lawfully, you must pay the price for the harm you cause. It doesn't matter when. Right. The common argument is legislation is law. That is incorrect. Legislation is not law. Common law is created by the people in Her Majesty's courts. So this is admitted, and what an admission means, this is not disputed. Okay, so that legislation is not law is admitted on their own website. If you go to understanding legislation, there's a section called case law, and it says very clearly, case law is the set of rulings from court judgments that set precedents for how the law has been interpreted and applied in certain cases. So what they're doing here is playing with words. What it should say is case law is the set of rulings from court judgments that set precedents for how the legislation has been interpreted and applied in certain cases. And it tells you very clearly there is no case law to be found on the government website. So this is further affirmed in the Boris Johnson judgment. Okay, if you remember back the prorogation judgment in 2019. So firstly, being creations of humans, governments cannot have authority over its masters. And in the Boris Johnson judgment, it clearly says the limits of prerogative powers were set by law and were determined by the courts. The courts have exercised the supervisory jurisdiction over the decisions of the executive for centuries. So this is nothing new. Okay, prerogative power is what creates governance, and that's always been subject to the courts for centuries. And it includes the judgment to say that even a standing minister is accountable to the courts for their lawfulness of their actions. So again, all of these footnotes are the supporting case law and judgments that give you standing for each statement we're making. Have you seen how we're making one statement on a line? Whoops, Control Z. We're making one statement on a sentence. Okay, now that there is what's called point by point. I make one statement and I provide my supporting evidence for that statement. So I'm making a claim because a statement is a claim, and I'm evidencing that claim. Okay, so that particular one, this is the case law which supports that statement. This is what's called standing. It gives you standing. I'm not just talking rubbish. This is my logic and reason why I have reached this truth. Okay, next is the Bill of Rights affirms the government is subject to the will of Parliament assembled. Carrie, that's my dinner. Leave it. Yeah. So again, the Bill of Rights says that the government must do what Parliament tells it, and it must do so promptly. The next law that we're relying upon, Carrie, sit, lie down, be quiet, stay, is that order following is not lawful excuse. And again, the case law that supports that is here. Carrie, out. 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 The case law that supports it is here. And what that further says is that any person, before they act, must verify and satisfy themselves that their actions are lawful. So go back to the person asking you to wear a mask, or the school saying we must test. They need to first show you that they've verified that it's lawful, before they breach another person's peace. Okay, so everything's about a breach of peace. You cannot breach another person's peace until you show reasonable evidence at the time. As simple as that. The next law that we're relying upon is collective punishment is not lawful. That means I can't just randomly punish all the people because one or two people are sick. But the test is that every person's actions must not be premature, indiscriminate, or disproportionate. Then we describe what is the force of law, okay, and it must meet these three following tests. The force of law is the way that you can test if anybody is asking you to do something. Is it fair and reasonable what they're asking me to do? Have they got a good reason for asking me to do it? So the first test is it must have a legitimate aim. There must be a good reason. The cause of action must be chosen, and chosen action must be rational. So the rationality comes back to the very simple thing. If you can't prove a virus exists, then it's obvious that everything thereafter is irrational and hence unlawful. Now, the rationality is not only for the considered action, but it should cover all of the options. Yeah, okay. The considered and chosen action. So if there are a variety of options, each of those must be rationally shown to be meeting the legitimate aim. Finally, for it to be lawful, the chosen action must be reasonable. And that's defined as the least imposing upon another's right. And if anything's irrational, it equals unlawful. And basically, the definition of irrational is any decision so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. Then the next thing that we are doing this year is a threat, okay? And it's specifically directed to people in public office. It's a serious offense and it can result with lifetime imprisonment. The elements of it are somebody willfully neglects to perform a duty or willfully misconducts themselves to such a degree as to amount as an abuse of the public's trust in the office holder without reasonable excuse or justification. So we've seen so far that basically each individual's liable for their actions. They need to check the lawfulness of their actions before. And we've read them their rights here so far. So we've told them what their rights are. And all of it is supported with case law. So the next thing that we're claiming is that coronavirus legislation has no legal authority. So this here is that the Coronavirus Act itself, 2020, specifically restricts the government to deal with coronavirus. It has no authority in any other act to deal with coronavirus. So we're asking them again here to put strict, it's called to put the claimant to strict proof, okay? And what we want them to prove is under part 1 interpretations, blah, blah, that severe acute respiratory syndrome coronavirus exists. And we're saying to prove that it exists, we want evidence of isolation without contamination of any other form of RNA of a complete claimed agent, the agent being the virus. Secondly, we're asking to show the identifiable unique harm, and then infection or contamination, we're asking them to prove is transmissible human to human. If they cannot do that, then Coronavirus Act 2020 is unlawful because it's irrational. The next argument is that basically because they've been using the Health Protection Act, I mean the, Public Health Act, Control of Diseases 1984, What we're saying is they have no authority to do that under the Coronavirus Act. So all the legislation in England, the secondary regulations, have no authority. They are illegal. So I go through detailing that. And again, we're asking them, even if they're using that, they still must prove that it's been isolated, is a threat, causes unique harm, is transmissible. Okay. Also, we're asking them to show the effectiveness of alternative measures considered, and that the selected measure is the most effective in achieving that objective. And we're asking them that this action is not prophylactic treatment, which is prohibited under section, which is prohibited as detailed below. As detailed. Next. Okay. Now, this as detailed next, this one here is something that has been overlooked. Even if they turn around and say we're using government regulations, okay, this is the point where they go wrong. Okay, section 45C(6) does not allow any prophylactic medication. So by following government regulations or making the claim that they're following government regulations, that is illegal, because all of section 45C is subject to 45E. Now, Dwayne will understand this because I think he's familiar with contract laws. And 45C says quite clearly, anything using 45B or C may not include provisions requiring a person to undergo medical treatment. This is their claimed authority. 45C, 45C, 45D. Okay, so here they list all of their claimed authorities under the Public Health Act. But to be able to use these, those are subject to no medical treatments, may not include the provision of medical treatment, and further, it defines medical treatment includes vaccination or other prophylactic treatment. So whichever way they argue their case, they have no case to stand on. They have no standing. So with this notice, we're telling them you have no standing. So what we ask next then is, because we want remedy for this, that we're giving them alternative options to provide us remedy to this. So by an undertaking, so if you promise that you'll be a good boy, okay, and do these things, then I will accept this as matter as settled. So what we're asking them to do is immediately notify their principals and agents of the notice, remove all coronavirus related material from public view, copy or use the undertaking in Annex 1, fill in the date, your name, and how you can be contacted, then sign it in the presence of 2 witnesses who must also sign, then scan or take a picture of it, then serve it to me by email and post as previously detailed at 3 above, as full and final settlement to this dispute. So what we're basically doing here is we're making a private settlement whereby here is the undertaking that we're asking them to do. Okay, so they basically promising to you, I'll be a good boy. And in the undertaking, what they're saying is this day, their details, their address, their email address. And they undertake that they understand just following orders is not lawful excuse, and they're personally liable for their actions. They understand that threats and intimidation many are under, and that fear causes most not to stand up and do what most know or feel in their conscience to be right. And I must no longer turn a blind eye. Further, the Bill of Rights is the founding authority of Parliament and undertake that they cannot create any enactment to the prejudice of the people. Next, and by the way, sorry, there'll be different undertakings, okay, for different people. This one's particularly for MPs. There'll be different ones for doctors, which will go about their doctor's oath and things like that. So the next is that the MPs, we're asking them no longer to vote on any political party line or on any other party's coercion. The next one, that they'll undertake to fulfill their lawful obligations and not vote for any unlawful bills. The next one, they will make every attempt to remove any unlawful legislation. They will undertake to vote against the renewal of the Coronavirus Act and any related secondary legislation. And they will hold the government to account, support the rule of law under their obligations of their oath or affirmation. And this here is the parliamentary oath. I, whatever your name is, will be faithful and bear true allegiance to the Queen, heirs and successors, according to law. Okay, so it's according to law and not according to the will of Parliament. It's a difference. So Dwayne, basically, we were discussing earlier about when the Queen dies, that's covered here. Yep. And then they sign it and they have two witnesses. So that's one option that we're giving them to settle our dispute. Another option is by rebutting our evidence. We've put in a claim saying that their actions are unlawful, so they need to rebut that. And the way that we want it rebutted is we want a full, accurate and complete point-by-point response to this notice. And then we're telling them how to respond. So by admission, denial with counter evidence, or asking for further evidence to prove my claims. We're giving them a time within which to do this. So I can't remember, somebody asked, what's a reasonable amount of time? It depends upon the situation. Basically, I would say with this, even 7 days is more than fair and reasonable. Why? It's been going on for 18 months. If they still can't prove that the virus exists or that it's transmissible, sorry, mate, you've had plenty of time to work out your evidence. Not my problem. If it was at the beginning of this, maybe you would consider 28 days as reasonable. But so long as you consider, what would an average person consider reasonable? What could I persuade you to believe was me being honorable and giving you a reasonable amount of time, acting in good faith and clean hands? Okay, so that's, I can't remember who answered that. I think that might have been Leah. So next, so this year was my right to enforce the people's peace, and under your obligation to keep the peace. Okay, I remind you, you can only claim what you have a lawful right to claim, and you cannot create a dispute when none exists. Now, these two here is what the next thing relies upon. Should you choose not to settle this matter honorably, in good faith, and with clean hands, as equity acts in person and will not suffer a wrong without a remedy, you will be charged for further breaches of my peace at the rate of £250 in legal tender per hour, part hour, rounded up to the nearest hour, per occasion payable within 7 days. And the reason is, no man shall set up his own equity as a defense any more than a cause of action. So if they claim anything they have no lawful right to claim, or they create a dispute where none exists, then you are under no obligation to give up your time freely for that. And you're telling them, I'm going to be charging you. And this is what's going to cost you if you mess around and do not respond accordingly. And then I've just added in another list of questions, basically to prove the point and run it home, which also require your answer. So here's another 12 questions or 11 questions, basically going through some of the obvious nonsense of the whole thing. What we're telling them next is if they do not provide the remedy, i.e. do not give us an undertaking or a rebuttal, okay, this will result in a warning. The warning will give them another 7 days or 4 days to remedy. Then we're telling them the effect of this notice, second notice, will remove their lawful excuse of negligence. Also, we're telling them it's witness 1 of your dishonor, bad faith, breach of peace, unclean hands to remedy the dispute and your breach of my peace. We're going on then to tell them if they still don't respond, they'll get a letter before action. We'll give them another certain amount of days. That removes their lawful excuse of gross negligence and is witness 2. Thereafter, the matter may be brought to public dispute settlement with your dishonor, bad faith, and guilty mind of your breach of both people's and my peace, but in any event is a record. Now, this here is because some people were concerned, if I serve notices, do I have to take them to court? So we may not necessarily take them to court. That's a choice we have. So this here is just basically saying, listen, no more further notices. I may take this matter for public dispute settlement now, or I may merely just keep it for a record for the future. Then we're all human. So accepting honest errors and omissions, I believe my actions of serving you this notice and the contents herein are honorable, lawful, and true. Then you just simply sign and date it. I've got a certificate of service underneath here. Now, this certificate of service is essentially, if you're issuing the notice by hand, you can fill this in and have your 2 witnesses again. So you describe the method of service, either it's served by hand. Hang on, let's just put that there with the, make it more obvious. Okay, those are your 3 different service methods. So just delete as appropriate. And if you served it by hand, enter who you served it to. If it's by recorded post, keep your proof of receipt. Okay, sending by post, make sure that you get it signed for delivery. That gives you proof of receipt. And if you service by email, basically this is the precedence, and you attach a copy of the email confirmation or bounce back delivery receipt. What you'll find with most of these official people, they've got emails, autoresponders saying, thank you for your email. What they've done by that is admitted they've received your email. And the certificate of service is whoever served it, witness 1 and witness 2 with their details. And so, like I say, the annex, I'll be making a separate undertaking for different people or professions. And you literally just need to pick the appropriate annex for, if it's, for instance, schools or doctors or that. So that's the whole notice and the procedure. Has anybody got any questions?
No, not for me. It's very, very comprehensive indeed. So thank you for all your effort and work on that, Mark.
Brilliant, you're welcome.
Just one from me. So if you send your first notice, notice is the 10 pages. Is your second notice the 10 pages as well, inclusive of the 4 days to reply, and your third notice, or your third notice is the last section, another 4 days to reply, and then you submit the same notice again. So ultimately it's the same notice, but you're completing section, the other 2 sections in terms of when, how fast you want them to reply.
Okay, let me just go through this other screen, which is sort of what I'm trying to put out, so that this basically is the directions, so to speak. Okay, so this introductory part basically is what are the notices, and I've put up a dispute resolution and doctrine of 3 notices modules on the Peacekeeper training site, so you can go through that. Then what I've got here is a schedule for MPs of the notices, if you guys want to serve MPs as well. And I'll email this out, but Dwayne, I'll probably copy it to you. I'm not sure if everybody's signed up and if I've got people's email addresses. So then it goes on to how to do it. So I'm asking people to spread the word, download the 4 attachments, and those are the 4 attachments, and then forward to anyone you think may be interested in holding the MPs to account. Then the next part is putting your MP on notice. How do I do it? Click forward to this email, insert your MP's name in the covering letter below, enter your name and address in the covering letter below, attach the appropriate notice, send to, enter your email, your MP's email address, copy to, enter the following 2 email addresses. These are the 2 witness accounts. In the subject, MP's caution notice to vote against renewal of Her Majesty's government power granted by Parliament assembled under the Coronavirus Act 2020. Then send the caution notice ideally before the 10th of September with the copies. If no response by the 17th of September, change the subject to MP's warning notice. So just simply change the green into warning notice. Again, send copies. If no response by the 21st of September, change the subject to letter before action notice. So again, basically all we're doing is changing the subject to each different notice. Okay, then delete everything above here. So that won't be at all in the notice that you're sending. So basically the MPs will receive this here. Notice to agent is notice to principal is notice to agent, email service in accordance with whatever the precedence is. Dear, enter your MP's name here. I, enter your name and address here. Do serve you this notice attached with the MP's caution notice. So we attach the caution. Remember here it says download these 4 files. This is the caution notice. Here's one of those files. I'm making a complete package, okay, with all the notices in it. So hang on, that one there's also F. We actually may not need these here. It might only be these 2 files. One is the MP's contact list and the caution notice. I'm just trying to finalize this because it looks like we can use this forwarding this here as the 2nd and 3rd notices. So basically, what we're saying is the precautionary period is now well and truly over. And to date, neither the Coronavirus Act nor any other legislation dealing with SARS-CoV-2 has an impact assessment. Now, I put in here, delete this line for caution notice and delete this line for the caution notice and the warning. Okay, so basically what we'll have is merely this. You have failed to provide a response as requested to my caution notice by the 17th. And then if they don't respond to the warning, further, you have failed to respond to my warning. So basically what we've got is, in effect, all 3 notices we should be able to do simply by just deleting these 2 lines and changing the subject area to the new notice. And so here, basically, you put to proof, blah, 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 it exists, etc., etc. You put here to prove you followed your due diligence and provide science that does not follow logical fallacies, including but not limited to circular arguments, which depend upon tests which themselves can only be calibrated against an isolated sample as opposed to any computer generated RNA, blah, blah, blah. So here then we again are asking them to prove much of what we've asked for in the notice. Now, and so this here, in effect, is all we need for the 2nd and 3rd notices, whereby the only thing that we change is what goes into the subject line for each of the notices, and we delete both of these when it's the caution notice. We delete this one when it's the warning, and we don't delete any of them when it's the final warning. Obviously, when I say that, I mean we delete this anyway, or this. So Dwayne, I'll send that to you if you can see if that makes sense. But so far it makes sense to me, and I'll send that out tomorrow. So the same format will follow for all notices. And if we can do it like that, I think it'll be quite, it'll be simple enough for most people to do. Don't know. What do you think?
Does anyone else want to say anything? Are they okay? Are you guys okay? Do you want me to speak? I know I speak a lot, but.
No, I mean, it seems straightforward to me. It seems, yeah, a naturally logical order. So, yeah, really well put together.
Thanks.
Yeah, I think everything is fine for me, but like I like to have like sort of documents just so I can go over and kind of absorb like all the information, because it's like still, you know, quite new to me. But you've explained everything like really well, really logically. Like, so I'm kind of understanding it, even when it's the first time, you know, I'm hearing this. So,
well, you're in the deep end, Leo, because really the notices is the final tool that we have,
yeah,
to try and force people to comply.
oh yeah,
but it's just like amazing, because this is actually, I think I'm definitely going to be using a lot of these techniques that you're talking about, you know, like, especially when things get harsher, like later on.
Yeah.
So, you know, obviously I still need to, like, you know, have a look at it, review, you know, soak it in, but so far so good. So thank you very much.
Good, you're welcome.
Yeah, and for me, it's been really good to tie it back to the videos. I'm about 60% through on the basic course so far. So just how it all logically comes together fits really well for me.
Right. But honestly, the whole system is really, really simple when you see it. Like I said before at the introduction sort of thing, we all are free to do what we want. As soon as somebody believes that we're doing harm, they must put us with that knowledge. And we use the notices to do that if they don't listen to us verbally. But essentially, as soon as somebody's authority is questioned, or the lawfulness of their actions is questioned or disputed, they should stop and prove their claim. And once their claim's been proven, then they can continue with their action. But until the claim is proven, we shouldn't be fighting or arguing about it. We should be civil, you know, and okay, I'll get back to you in a week or 10 days with all the proofs that you want. So we shouldn't be fighting about anything. There's absolutely no reason for fighting. And
yeah, I mean, for me, that's the genius thing about this this process that you're applying, right? You government agent are asking me to do something different, prove why I should do that different, and that puts the onus on them. And we all know collectively they can't prove that. And actually, you know, for me, I see this as you know, waking up a lot more people that are in those positions of responsibility, because you know, the hope would be that they will try and get together that information and discover that it isn't available. Correct. And then start to question themselves, thinking, well, why isn't this information that should be readily available, why isn't it available?
Correct.
This can also be used for media. We can also send it to the media agencies as well, which is very important, because they're the propaganda arm of everything. You know, they're the ones who are pushing everything. So if you start, you know, issuing it to them as well. Yeah.
And basically with the media, you know, like you said, Wayne, but it's the same. If you're reporting and making claims that so many, you know, people are killed by coronavirus or whatever, or are sick, okay, this is how you're meant to calculate and correct for the false positives, because based upon the formula, and many people don't realize this, there's somewhere between +3 million and -3 million COVID cases in the country, if you apply the correction. Now, what it basically means is, even if there is a positive, we don't know if it's a real positive or not, a false positive. We don't know if it's a 5% chance or a 100% chance or a 0% chance. All that we know is per 100,000 or per million, 4% of them are wrong. So it's actually the false positive dependent upon the total number of tests, not any individual test. It tells you nothing about an individual test. So once we put the information to the newspapers of that, basically every time they report figures, they need to put in a caveat. This means they could be anywhere between, you know, 0 and, you know, who knows how many cases. So that's another place where we can start to use it. The main thing is that people start to understand it, get the courage in it, and understand what it's doing and how it operates. That there then gives the power for us to start to apply it to a much broader spectrum. So
in terms of if an MP is to respond, for instance, to the first notice, just let's just say they do respond, and they respond with blah blah, you know what, you know, because 9 times out of 10 they do. They'll always refer to legislation, and they'll pop a whole bunch of different legislative aspects in their reply and say it's lawful because of X, Y, and Z. Have you got something ready to?
Yeah, within that notice that I've shown you, it's already there.
Oh, so the bottom part where you said there, that little part at the bottom,
yeah.
So in other words, don't blag me. You need to provide the evidence.
Correct.
Yeah, gotcha.
So basically, specifically, I've addressed legislation at point 20. So here I've had a direct rebuttal that their legislation is legal. Okay. I've asked them here, you need to prove that for the Coronavirus Act to be lawful, and you need to prove this for your secondary legislation to be legal. And in addition, I've asked them up here, for instance, collective punishment is not lawful. That there itself says, you know, if there's 1% of the people that are sick, you can't punish 99%.
99%, exactly, yeah. And that's been my argument as well since the beginning of this thing.
Yeah. And basically, this is the irrationality. If they can't prove it's rational, then by meeting these tests, then it means automatically it's unlawful. And specifically for the MPs, I'm telling them, misconduct in public office, okay, can be lifetime imprisonment, okay? If you willfully neglect to perform your duty, and or willfully misconduct yourself. By you not giving me answers, by proving these things that I've asked up here or down there, wherever they are. Okay, you know, these sort of things here, and what, you know, this stuff here. If you can't prove all of that stuff, do you realize that you potentially can get lifetime imprisonment because you willfully neglecting to perform your duty? You have a duty of care to ensure under the Commissioner of Police, individual liability, wherever that is. Here, order following is not lawful excuse. Okay, so if you order following by doing party line votes or listening to somebody else how to vote, you are in breach of your duty. Where was it?
Number 12 in your things.
Okay.
So it's the one above there.
One above that.
Just there, 12 down the bottom there.
Yeah. So basically, what I'm doing is telling them this is like, you know, lifetime imprisonment because you willfully neglecting by not responding, or you willfully misconducting yourself. And that is an abuse of the public trust in your office. You are meant to be doing that. And if you can't answer my questions, you've got no reasonable excuse or justification for doing anything other than voting against the renewal. So I'm trying to just hit them with all angles.
Yeah, it's pretty good, to be honest. It's pretty good, you know. And
so basically, with minor modification, we can use this for teachers, we can use this for doctors, we can use it for anything.
Yeah, that's cool. All right, that's no problem. I mean, unless there's anything anyone else wants.
What I'll do is tomorrow, I haven't quite finished, as you saw. I still just got to try and get all the instructions on the email, so to speak, done.
Emika has raised her hand. I don't know if she wants to say something.
Yeah. Yes, thank you very much, Mark. It is very clear and very logic, and so much information in it. But you know, it's very easy to follow because today you show us, you know, the document. Yes, you know, as Leo said, we want to, you know, have this paper available so that, you know, we can just, you know, delete it more and then, you know, have more understanding. But, you know, as Kieran said, I really don't want to fight unnecessarily at all. No, that's why this, you know, the way it's so clever, and we feel like now we can sort of like, you know, feel much safer because, you know, I felt like, you know, that we are kind of, you know, the position to be attacked. But now, you know, with this kind of a very good defense, very peaceful defense, we can really protect ourselves. So thank you very much for all your hard work. We really appreciate it. Thank you, Mark.
No, I mean, basically, the thing is, I've been fortunate enough that I have an interest in this stuff, and I've had time to research it and pull it together and learn from other people. It's nothing unique to me about this. It's just applying what I've learned.
Well, anyway, thank you. You know, you are too modest. Thank you very much.
Thank you. Okay, Dwayne, I'll get it off to you. It should tomorrow. It should be pretty well sorted.
Yeah, the MP one's no problem. What I'll do is I'll have a read through and see if I can try and modify for schools.
Yeah,
and then I'll get Kieran. You know, I'll get in touch with Kieran and Emik and them and get email addresses. I think some of the other guys are a bit busy this evening. Some of them are on holiday as well, so they couldn't make it. But I'll get I'll get some email addresses, send the detail through to them, and
Right.
then we can start on our side and start keeping our own records, and sort of work together collectively.
Absolutely.
And start issuing these things as soon as possible, really, so we can start the ball rolling, particularly in regards to, so I'll probably go with my MP anyway. He knows who I am. I've sent him a few letters in the past. So
Yeah, no, that's brilliant. No, I mean, ideally, if people do it in person. The other reason, basically, I do want to keep a record of which MPs have been served. So I'll more than likely do my local MP when I find out who it is, and do it in person if I can, because it's local to me. Then I can do all the pushing and everything. And if we've got 3 or 4 people that are prepared to take it to courts, that then will immediately start to do some serious shaking, and people will start to get concerned then.
Yeah, let's start poking ears as well. So
Yeah.
ears will start popping up and people will start paying a bit more attention. And so
Yeah.
it's just like you say, I mean, we are where we are, and it's a shame it's, it's 18 months down the line. But
Yeah, no, I just wish I'd started this 5 years ago. I think I said to you when I spoke to you the other day.
Yeah, I know. So it's it is a shame, really, because
Mm.
but so things just happen, so sometimes things happen, and for whatever reason some can explain,
Yeah.
some can't, so it just happens this way. So I suppose we can only do the best that we can in terms of the world that we live in. So
Absolutely, yeah. Okay, my friend.
yeah, listen, take care of yourself, and like I said, if you want to email me, then just let me know, and I'll make adjustments, and then I'll sort it out. So
Yeah.
Yeah,
Well,
like he's just been working, so it's a shame he couldn't make it, because he was the one who said I should have it on Monday night, but it's no problem.
If you can send a link to the recording, Dwayne, and then we can put it up and just direct people to it.
Yeah, no worries. I'll see if I can load it to my YouTube account and just use that.
Okay, that would be brilliant, mate.
No worries.
Thanks.
Perfect. Thanks, guys. Thanks, Mark.
Okay.
Much appreciated.
Thank you.
Cheers.
No worries.